7:30. All right, welcome back. Welcome. Shh. We have 2 full classes left and a review. Right? We have class today. On Wednesday, we cover the First Amendment. On Monday, we do the travel ban. And after that, there's no class on the 14th. And the 19th, we have review. So we are almost at the very, very end. One note that might be of interest. Most of the student events happen during the day for a host of reasons. One of them we're having at night, kind of night. So on the 12th, so a week from today at 4, from 4 to 5, the Law School's Federalist chapter is having a Supreme Court roundup. I'll be speaking. One of my good friends, Ilya Shapiro from the Cato Institute, will be speaking. He is the one who gives us all the constitutions. He donates them, so you can pay it forward. And also Justice Massengale from the First Court of Appeals in Houston will be there. And we'll talk about the Supreme Court's term and a lot of stuff. So if you're around at 4, you should come. Hope to see you all there. I know most of you aren't, but hopefully some of you can attend. I'm sorry?
What happened with the constitutions at your house?
Oh, I gotta show you this video. Oh, okay. Thank you for reminding me. It was a smashing success. Okay, here. Let me. I'll play this. I don't have time for it. I'll play it anyway.
Oh, look at this!
Okay, hold on. Why is it not playing? No. Why is it not playing? Oh, it's a still. Okay, let me get the video.
For the Constitution.
Yeah, here it is. Here, it's cute.
It's the Constitution. You guys are watching that.
Can't come to the door. Enjoy. Oh look, this is the Constitution of the United States. All of the Constitution. Isn't that wonderful? The Declaration of Independence. Like you've already got that. Here, just a couple of pieces of this, and that's it. Wait.
You want more candy?
Just take a piece. That is so nice. Thank you. These are wonderful houses.
They all come.
That they have a Constitution of the United States.
Watch.
What's the Constitution?
What's the Constitution?
I'm taking one of these. Paula, take one of these.
I got one other video to show you. And this one's short, it's like 20 seconds. This girl's my illegitimate daughter, I'm sure. No, listen to it. Here.
I'm here for the Constitution.
The surveillance state's good sometimes. Anyway, that was fun. All the constitutions are gone. I actually had extra candy, but I ran out of constitutions, so that's the right ratio. That's a ratio. So next year I have to up my game and have more constitutions. I actually asked Ilya for 100 more for next Halloween. Anyway, I was actually getting all the alerts while I was teaching the class. Like, oh, I couldn't really do anything. But anyway, there it is. Okay. Anyway, so we're basically done, right? We don't have much time left. We have class today. We're doing the First Amendment briefly on Wednesday, the travel ban on Monday, and then we've reviewed the last day of class. I've canceled one class. We'll be out of town, and then we're done. So we're almost there, my friends. We're almost there. I met with roughly 2/3 of you yesterday and Saturday. I was here all day Saturday till 9 and all day Sunday till 9 again. I have one more session on this upcoming Sunday. If you didn't come for any reason or didn't make an appointment, I think at this point all the slots are filled. Some people registered for multiple slots and didn't tell me. So that's why we have more students than slots. It's annoying, but I can't really fix it. I don't know who is who. So if you need to come by Sunday, just show up and I'll be here all day and I'll find a spot for you. Not ideal, but I'll make time to meet with you one way or the other. Okie doke. Anything else? All right. So today we have a lot of ground to cover. I used to cover this in 2 classes, but now I cover it in 1. As the nature of this topic evolves, I have to condense things and then eventually drop things. When I first started teaching, we didn't have a Obergefell and we didn't have Windsor. We only had Lawrence and Romer. And then we added Windsor, and I did an entire class on that. And then when I had Obergefell, I did an entire class on Obergefell. Now I've condensed them and added a class on the travel ban case, which will be a capstone for us. But I do want to synthesize all these cases together. And one factor that Romer, Lawrence, Windsor, and Obergefell share in common is that they're all written by Justice Kennedy. He wrote all of the major cases in this entire unit. A second element that unites these cases is that they don't follow the doctrine that we thought was supposed to apply. They don't go through the usual hoops of saying what is a fundamental right. They don't jump the hoops of saying what is a suspect or a non-suspect or a quasi-suspect class that gives you scrutiny of strict or scrutiny of intermediate. Instead, Justice Kennedy is motivated by something very different. We saw this in his Casey plurality opinion, where he focused extensively not on privacy, on the right to privacy in Roe, but he focused on liberty. That is, liberty to do as you wish in certain spheres. And you see this very strongly in his cases involving Lawrence and as well as Obergefell. But to the extent that there's a word that unites all 4 of these topics in Kennedy's opinions might be dignity. And that's not a word that's in the Constitution, but Justice Kennedy sure thinks it is. And he puts lots of emphasis on laws that deprive people of dignity. And there's a second concept that unites them. Justice Kennedy firmly believes that laws that are based on moral disapproval, that is merely thinking that someone's acting immorally, are improper. And that when you are restricting someone based on a vision of morality, you're in fact acting to harm them. And acting with a bare desire to harm someone, Justice Kennedy writes over and over again, is not a rational basis on which governments can act. So where does this leave us, right? Last year when I taught this case, I said, well, we'll have to see what Justice Kennedy thinks about the next topic. I can't say that anymore because he is no longer a member of the U.S. Supreme Court. And what he thinks is utterly irrelevant now. So that's why I'm more comfortable condensing this into one class. And Randy wants to drop Windsor from the book altogether. He may be right, I don't know. But we'll see in due time where and how the court takes this direction and whether the court maybe retreats and maybe goes back to a more historical-based approach to identifying fundamental rights. I'll just give you one preview. During Justice Kavanaugh's hearing, several senators asked him, what's the approach for identifying fundamental rights? And he cited the case of Washington versus Glucksberg, right? Over and over again, he said Washington versus Glucksberg. Rights that are deeply rooted in history and tradition are protected. And none of the senators are smart enough to press him on it. They really should have. Kennedy basically disregarded Glucksberg in the Obergefell decision. He basically overturned it. But he didn't. And the basically part is important because the fact that Obergefell never overturned Glucksberg means it's still good law. And I would be willing to bet all of you a basket full of Halloween constitutions that in the next major case, a more conservative court resurrects Glucksberg. So I've been fighting Randy for years. We should cut Glucksberg out of the book. It's not good law anymore. But I think now, we'll see the court resurrect Glucksberg in the next major substantive due process challenge. All right, so any questions in that frame? Okay, so let me get you started with this question over here, if you guys can see it. And I phrase this question in a way because I want to actually drill down a bit on what it means to have a rational basis. So the question for you guys is this. Is it a rational basis for Colorado to mandate that all local municipalities have a uniform policy with respect to sexual orientation discrimination? That's your question. Is it a rational basis for Colorado to mandate that all local municipalities have a uniform policy with respect to sexual orientation discrimination?
Does that specify, is it for or against discrimination?
I phrased the question as I phrased it, Mai. That's why I phrased it. By the way, her sandwiches were really good, weren't they?
I'm bringing it back on the last day we have class here.
Okay. They were delicious. Thank you, Mai. Okay, who's up next?
I was sitting and I was
Oh, what honesty.
sick.
All right,
Feeling better, so.
I appreciate that. I don't want to do this. I'll come back to you eventually. We'll get to you because if I do this,
I did. I was the last person.
you were like, you're not volunteering.
I
I
just
see.
want to make sure you get to James.
James, we got the itinerant student, the wandering student who moves around to avoid the role. Yeah, James. Ooh, crap. Or does it is it transitive? Wherever she sits, I put the next to her.
I'll go.
James, what do you think? I'll get to you eventually. What do you think the answer is? True or false?
I think it's true, but the case goes more towards false.
Well, let's just. What's the rational basis for a state having a uniform policy of discrimination ordinances for sexual orientation?
Efficiency.
Why is it efficient?
To have everyone have the same policy rather than doing laws for one group versus another group.
Well, not just one group. I'm saying, say, the city of Denver has one policy, and the city of Fort Collins has a different policy. Why might that be problematic?
So everyone knows the same policy.
Ah, yeah. So I mean, one of these days you'll have a business, right? Maybe you already have a business. And let's say your business is so successful that you have offices throughout the state of Texas, right? One of the biggest costs of running any business is compliance, right? What are the laws you have to comply with? Right? So if you have a business in 15 states, you need to have the laws of 15 different states. You have to comply with them. So if you have an office in one state that, say, requires maternal leave, in that state you get maternal leave. If you have another office in Texas which doesn't, your employees do not get that benefit, right? So you have to be very careful to comply with local laws. So if Colorado says, we want to make businesses have a more easy climate, and we don't want them to deal with competing discrimination regimes in this county, and this county, this county. James, is that a rational basis for the government to act? Okay. Now, so Justin, let me ask you a follow-up question then. Do you think the people who voted for Amendment 2, was it Amendment 2, right? Amendment 2, right? Amendment 2. I always get the numbers confused, yeah. Amendment 2 in Colorado. Do you think they were motivated by uniformity of business practices? No. Do you think it was a ballot initiative, right? So we don't ask people why they vote the way they do. But if you were just to take a guess, right, would a majority of the people who voted for the amendment number 2 said, we're doing this because we want to have efficient business and uniform license practices?
Well, they did it because they were probably heterosexual and wanted to discriminate against.
Well, we'll use a disapprove rather than discriminate. But you can use the word you want, right? But I want to use the word of the case. So what do, right? You have an initiative for which there's absolutely a rational basis, having uniform business practices. But then a certain percentage, probably a majority, probably an overwhelming majority, approve of this measure because They want to disapprove of gays and lesbians and don't want to give them any sort of special privileges in the law, right? What do you do when it's mixed like that, right? Where you have, I'll assign a number. Let's just say it's 98% disapproval, and let's say 2% business owners saying, yeah, we want to have uniform business practices. Okay. Austin, let me ask you another question, please. Let's take DOMA, for example, Defense of Marriage Act. Right? We all know that under the Defense of Marriage Act, the reason why these laws exist was to limit the federal definition of marriage to a man and a woman, right? Now, I'll get to the reason number 2 in a minute, but one of the primary reasons why this law is actually legally important was choice of law questions. Now, I mentioned earlier that conflict of law will be on your bar exam. You should probably learn about it, but I'll give you a brief introduction here. What happens if a couple was married, a same-sex couple was married in New York, and they moved to Alabama, where gay marriage was not allowed, and they file a joint tax return? Does the federal government apply the law of the place of celebration of the marriage, or do they apply the law of the domicile? These are actually difficult questions, right? What if in general you form a contract in one state, but you execute in another? Which state's substantive law applies? You all learn Erie. Oh, you apply the law where you are. What if you move around, right? What if there's a tort in a state near the place lives in? So let me tell you, Austin, that there were actually legitimate choice of law questions that DOMA addresses. The DOMA made it much easier for the federal government to have a single definition, and they didn't need to modify their tax laws and everything else in 50 different states. Was that by itself a rational basis for the government to define federal law? Just that by itself. Awesome.
By itself, rational basis, I think, yeah.
Yeah. Okay. So we all agree. That by itself is a rational basis. But then the statute has a legislative history, right? And there are reports that accompany the statute. And Austin, the statute says that we pass a statute to express a moral disapproval of homosexuality. And that's verbatim quote, moral disapproval, right? A moral disapproval of homosexuality, and basically a superiority of heterosexual opposite-sex marriages. So again, Austin, if you were to poll the members of Congress who approved of DOMA, and President Clinton who signed it, and everyone in between, and you said, who here was thinking about choice of law, right? And who here was thinking about moral disapproval? How do you think that vote would break down?
I think more would probably vote on the latter. More disapproval.
Yeah, I think you're probably right. I think that makes sense, right? And indeed, President Clinton signed this in September of '96. Check me on the date, but it was right before the election. Indeed, usually when you sign major legislation, you do it with a signing ceremony with cameras and everything. He signed this in late at night with no cameras there. He later said he regretted it, but he signed it when he signed it, and you could say what you will about that. So how do we do this, right? Where you have a statute that has an absolute rational basis to support it, but there's probably a secondary motive, or a primary motive, really, that overwhelms. And that overwhelming basis is moral disapproval. Now, I keep using this phrase, moral disapproval, right? Why am I corrected Justin and said discrimination, but why am I using this phrase, moral disapproval? It comes from Bowers. That was the phrase that Justice White used in Bowers, right? 5-4 decision. And Justice White said in Bowers that moral disapproval of homosexuality is a rational basis on which a state could criminalize sodomy. You said it. I mean, you can go read it, check your notes. That phrase is there. So imagine this, right? Bowers is a good law. It's on the books. Congress enacts DOMA, and they put that phrase in there, not by accident, but they put the phrase from Bowers in their statute, in DOMA, in the legislative history, in the findings. Then we get to Lawrence. Lawrence overrules Bowers, right? And Lawrence suggests that that moral disapproval, in this case at least, cannot be a rational basis. At that point, DOMA is dead on arrival, right? DOMA is DOA, I suppose, right? DOMA, right? It has no chance of succeeding. But then we get to Obergefell, and you see something change, right? In Lawrence, the court makes an effort saying we're limiting ourselves to sodomy. This in no way undermines the state's institution preserving marriage. And you have Justice O'Connor, her concurrence in Lawrence. She says, well, there's still a rational basis to preserve the institution of marriage. That's 2003. Then you get to 2012, or sorry, 2013 with Windsor. 2013 in Windsor. And the court there says, our ruling is limited to lawful marriages, that is, those legally performed. Now, none of us believe that, not for 1 minute. Justice Scalia, I would describe as Kenny and Scalia is like a game of Tom and Jerry, right? Where Scalia is always chasing Kenny, but he knows he'll never get him. And in every dissent, he says the same thing. He's like, look what you guys are doing, right? You are dismantling the structure on which laws based on morality can exist. And every time you assure us this is limited to, this is not going to cover gay marriage, you are lying. And then finally, when you get to Obergefell, it's, I told you so. Indeed, after Windsor, a lot of district court judges cited Scalia's dissent. They said, hey, Scalia was right. This does lead to gay marriage. And, they thought they were being really cute. I thought it was silly. You can cite the majorities just as well. But the process from Romer to Lawrence to Windsor to Obergefell was in no sense preordained, right? Lots of things could have happened. But there was almost a perfect storm, a combination of factors over that 20-year period that led to the court's decision in Obergefell. It could have just as easily gone the other way. If one other justice had been appointed by a conservative president, if we didn't have Anthony Kennedy, we had Robert Bork or Doug Ginsburg, right? If President Obama lost the 2008 election, it could have very likely come out the opposite direction. Okay. One last factoid, and I'll go into the cases. When I first taught Windsor in, oh my goodness, maybe 2012 or so, it hadn't even been decided yet. I think I was taught it when it was still being litigated. I found this chart, which was from Nate Silver. He's now at ESPN, but back then he was at the New York Times, a 538 blog, which I know none of you are reading tomorrow night. You shouldn't. Stay far away from that stuff tomorrow, man. Just get fresh air tomorrow. It's going to be a long night. But they put this chart online, and this was published in 2012, and it projected when you'd likely have support for same-sex marriage at a 50% mark for ballot initiatives. So back then, Nate was still thinking that people would vote for gay marriage. That's what a quaint idea. But what you can see is by 2008, only a handful of states had majority support for same-sex marriages. And then by 2012, when this poll came out, it was roughly half the states in the union. And you can do red and blue just as you wish. But he forecasted forward to 2016 of which states would be added, and it became a significant plurality. I don't think Texas was on that list, but by 2020, even Texas would have made it. Mississippi's was a long way off, but even by 2020, you would have almost a supermajority of the states that would have had it. So what does that mean? Right? If you have a social movement that's growing at a pretty fast clip, that in the span of basically a decade, almost every union in the country have had popular support for gay marriage. How does the judicial process play into that? Right? And Justice Roberts, I think, makes this point in his dissent. It stops the debate. It no longer matters what we think because the court decided for itself. Now, by the time Obergefell was decided, it was almost nationwide a 50% issue. These charts accelerate. I don't even think this would be the correct trajectory, but it was already a majority issue in most states. But when the court makes these sorts of rulings, they take it out of the democratic process and they leave it for judicial resolution. Now, one of the ironies is the court recognized a right to same-sex marriage before federal law protected discrimination on the basis of sexual orientation. Usually, Congress comes first and the courts come second. There's also civil rights, with the Civil Rights Act and these various things. But here, Congress hadn't even passed a statute to give federal protections to gays and lesbians, and the court acted first for marriage. That's actually where we are today, although a number of courts have now held that the Civil Rights Act passed in the 1960s, in fact, does protect sexual orientation discrimination, just we never knew it until recently. But this was the choosing of Justice Kennedy. All right. So questions in that frame? Yeah, Mia.
How is it the choosing of Justice Kennedy to acknowledge the equality of an individual? Like, it's innate. I mean, are you saying the articulation of it was the choosing of Justice Kennedy in terms of the application and the opinion? I just, when we had the discussion last class, you said, like, a right is inherent, correct? Like, so even if a law deprives an individual of that right, or like Thomas said in one of his dissents, like, dignity is inherent, like a law can't give somebody dignity, but a law can prevent somebody from having access to a right. I just don't understand how it's Justice Kennedy's choosing. It seems like that's what the law is. That's what the 14th Amendment says.
What does it say?
That no state shall deprive, and it says either persons or citizens, depending on which sentence of Clause 1 or Section 1. Life, liberty, there's the Equal Protection Clause, and then there's the Privileges or Immunities Clause, which means nothing because of the civil rights.
How do you know what liberty means?
Even if you don't look at liberty, which is what he all does here, if you look at equal protection, I look at this more as an equal protection issue, though. Okay,
then how does it deny equal protection?
Equal protection of the laws means equal application of the laws, right? So if an individual is denied rights on the basis of their class identification, like privileges to have a license that gives them inheritance privileges, that gives them privileges of in medical situations with their significant other, that gives them a right to not be a criminal for practicing their identity. That would be equal protection because the laws are targeting those individuals and criminalizing them for being themselves.
One of the first examples we gave in class is driver's license and age, right?
Yeah.
Why should sexual orientation be treated differently or the same as race?
Because you can't change your sexual orientation.
Some people might disagree with that.
Some people thought that African Americans didn't.
No, you can't change race.
Yeah, no, I'm saying, but some people thought, like, some people would disagree with that. Some people disagreed with the equality of African Americans in the 1860s.
Guys, just one at a time. Let her talk. If you want to talk, raise your hand, please.
I think that the concept of whether people can change it is influenced by their perception of that class. And so if they're allowed to apply that perception, that moral perception of that class in the prevention or access of their rights, I'm not saying special rights, I'm saying the same rights, the same privileges that are accessible to everyone else, then that is comparable.
All right, I have Kanisha, I have Monika, who else had their hands up?
So no.
I'm calling you.
Right, I'm saying no. That doesn't even make sense. So you can't change, those are two completely different things. Even with modern technology, so we talked about this a little bit last week, with modern technology you can change, I don't understand if it's the sex or the gender, but it would stop. You can be black and all, but you can't do that. That's not even, you're comparing two things that are completely different. I don't even understand how that's the analogy. I kind of sort of followed it a little bit until we got to that part. So maybe we can.
Well, yeah. Monika, I'll get you in a second. I promise. So, I promise I'll get to you. When we're talking about, guys, just one at a time, please. when we're talking about suspect classifications, right? One of the factors that makes something a suspect classification, why age is different than race, the court has said is something is innate, that you're born with, that you can't change. I'm not an expert on sexual orientation, but sometimes it can be described as fluid. So indeed, the courts moved away from recognizing innate characteristics. The court doesn't actually rely on that anymore. Instead, they don't focus on conduct and say your status. But that's one of the difficulties, I think, of why Justice Kennedy doesn't go down the scrutiny route. It just doesn't matter to him, right? Indeed, Justice Kennedy treats sexual orientation as a non-suspect class, which is governed by rational basis review. But the sort of rational basis review he applies is not like the age driver's license example I gave you guys a minute ago. It's very different. Monique, okay, patient waiting, yeah.
Just for me as first point, I think the whole premise of all of the readings that we did today, there's an argument going on about what exactly counts as a fundamental right. Everyone is not agreeing with the fact, or I wouldn't say it's a fact, but with the supposition that being a homosexual is a fundamental right. That's the whole premise of these cases, is the argument. Is it something that is just inherent? Is it something that everyone has a right to? Or is this not something that everyone has a right to? Also, to go towards race versus sexual orientation, I know people who, as I'm sure that we all do, who are homosexuals and who say that they are born that way, as well as I know people who had a really bad experience being heterosexual, and so they change that way. So it is definitely a fluid sort of identity, but to say that race, something that you're born into, something that you can't change, even if you wanted to, and I don't want to, but you can't change it. You can't compare that. That is okay. Disrespectful, I would say, to compare it.
Guys, just don't laugh, please.
That is a choice.
Okay, don't laugh or chuckle.
No, I wasn't trying to be disrespectful.
Okay.
I wasn't.
Let me just interview for a second. Can you get 2 seconds? All right. So, guys, just raise your hand if you want to talk. This will keep it.
In jail, like that's disrespectful to even laugh at her.
Okay, guys. If you want to talk, raise your hand. That's the one rule. If you want to follow the rule, I'm going to lecture. Okay. So let me try and respond to Monique's point, and I'll try and incorporate something else. The vote in Obergefell was 5-4, right? It was a 50-50 issue nationwide. Maybe 51-49, 52-48, whatever that number is. I don't have the numbers in front of me. But there's an issue in which it's so socially divisive, and which of course puts 5-4. Is it self-evidently true?
Right, that's the point.
Right? The fact that reasonable minds can differ, right? The fact that people, lawyers on the court, 5 or 9 of them, however they are, the fact that people can disagree, that means precisely that it's an issue that people disagree on. So when you're saying that a right is fundamental, that means there's got to be a pretty high level of agreement that that's the case, that something's wrong, right? In order to say that some right's fundamental, there's got to be some pretty broad agreement that this is the case. But in cases that we've done involving, I'm going to exclude Lawrence, because I think on the sodomy one it's actually pretty wide agreement as well. But I'm going to talk about the gay marriage issue, right? If you want to talk about abortion, to this day, it's not 90-10. The numbers fluctuate 60-40, 50-50, whatever. The numbers are less important. There's still disagreement, right? So when the court takes a socially divisive issue on which there's widespread disagreement, and then they try to resolve it with a single decision. Now, one reason why the abortion cases are different than the gay marriages, in the aftermath of Roe, it's like every day, overturn Roe, right? In the aftermath of Obergefell, it's like, okay, that wasn't that bad, right? You didn't see the sort of sustained backlash to the gay marriage decision as we see every day to the abortion cases. So for whatever reason, I couldn't tell you why that's the case. You see a very different reaction to these different things. Okay. Hands, I don't remember who was up.
I'll give you a hand.
Okay, Kyle. All right. Okay, fine. Okay.
So we got into some very murky waters. But I just want to say there are parallels, although obviously it's not the same, between sexual orientation and race. as far as whether it's innate, I think it doesn't matter. I believe it's innate, okay? And then also in terms of discrimination, you have like a long history of people being discriminated against solely on that basis out of moral disapproval. So that's the parallel. Obviously, there was no enslavement on the basis of sexual orientation, and obviously there are people that disagree on the definition of what sexual orientation is, and that, like I think Monique said, she has a friend or friends that decided to change their sexual practices based on their experience with one gender or the other. So I think it fundamentally matters how you define what you mean by sexual orientation as opposed to sexual conduct. And I don't think that any of you guys would say that you can will to desire someone of the same or opposite sex, depending on what your default orientation is. So maybe you will.
Yeah, Jess.
Okay, so let me ask you, just to clarify. Okay, so you said the fundamental right there must be broad agreement if it's a socially divisive issue.
Well, that's not the court's approach. That's
No.
I'm trying to respond to the court's approach.
So the broad agreement, among who? Who did you mean?
What a good question. I didn't say, did I?
No, that's.
See, this is why she asks good questions, yeah.
That's where,
Right, so let me ask this question, right? Let's go back to Loving, right? A case we did a couple weeks ago. This was the interracial marriage case, right? Was there broad agreement in the northern states, for example, that the interracial marriage bans were immoral? I'd say if you took a poll in the northern states, probably the answer is yeah. If you took the same poll in the southern states, I think the answer might come out the opposite way. So then, why then did Loving come out the way it did? So I think the easy answer for Loving is that it was an equal protection case, right? And that you have a racial classification for which strict scrutiny is afforded. But if you remember at the end, Chief Justice Warren has a section on due process. Now, if you ask me my opinion on Loving, I think it's an incident of slavery, that the anti-miscegenation laws were actually vestiges of slavery. And I think I can kill them PRI, which I think will be a little bit easier. But the court does say marriage is a fundamental right. And if marriage is a fundamental right, does that mean then marriage has to be extended to people who aren't of the same, or who are the same sex, right? So we've seen this a few places. I'll get back to your question, I promise. Where the courts said things like that marriage is essential to our survival. It's essential to the pursuit of happiness, right? You've seen these phrases in Griswold and in Myville, Nebraska, and elsewhere. I think I flagged at the time. Why is that the case? Reproduction. Historically, why was marriage... Oh, let me give you this one, right? Historically, why was marriage important? There's a simple reason. I'm sorry?
Oh, yeah, babies.
But not just procreation. The phrase was responsible procreation, right? Let me explain why. At common law, if you were born to unmarried parents, you were considered illegitimate, a bastard, if you will. I don't like that phrase, but that was the phrase that was used. And let me tell you something. At the common law, in certain states, not everywhere, but in certain states, if you were born to unmarried parents, guess what? You could not inherit property. And back then, you wanted land, that's how you got land. You inherited your property. So there were certain disabilities imposed on unmarried people. One more thing. Today we have divorce on demand. In almost every state in the country, if you're married and it's not working out, you can go to court and you can say irreconcilable differences. There are various differences in state by state which are not important, but no one's forcing you to stay married. At common law, you were married unless there was allegations of adultery or abuse, of neglect, or maybe abandonment. You're stuck. Till death do you part, as they say, right? But why was it so rigid that you had to stay with a person that maybe you hated to death and you wanted to kill, right? For the children, right? For the children. I can't even make my own punchline. It was for the children, right? It was to have a stable environment for the kids. Even if the parents hated each other and because of their hatred raised the kids poorly, the presumption was we want to have a legal structure established where the parents are there for the kids, right? That was the reason why you had civil marriages. That's why you gave various benefits to civil marriages, okay? But over time, that fades, right? You have, what do you call it? no-fault divorces, where you can get divorced for anything, right? You have children of unmarried parents are treated in the eyes of the law in the exact same fashion as unmarried children. You have laws on adultery and the like that just go away. We don't really talk about that stuff anymore. Maybe the alienation of affections in South Carolina, but that's not a thing. So perhaps at one point, there was a very strong reason why marriage exists, to channel kids towards a family unit. But what happens if that purpose, fades, or it's no longer relevant? Does it remain a rational basis to keep a marriage law in effect? Because maybe at one point it was good for the kids, but now it doesn't really matter, right? And that gets sort of what a rational basis is, right? Is a rational basis a test that must survive the moral philosophy of every judge in the Supreme Court? Is a rational basis something that has to meet, statistical accuracy? Think of the Craig v. Bourne case with the driving, the drunk driving statistics, right? Does rational basis have to mean it's 100% perfect, maybe 90% perfect? Is this proof beyond a reasonable doubt? Is this preponderance of the evidence, right? How strong must a rational basis be? If the Colorado Amendment guarantees having uniform application of the law, is that rational? Yeah. Are there other reasons? There always are, right? If the Defense of Marriage Act will help mitigate federal choice of law questions where you don't want to have different definitions of marriage, right? What happens? Going back to Janice's question, which I promised you would, right? If you have an issue on which the majority of the Supreme Court thinks that it's an easy moral question, and then you have an issue in which 50% of the nation thinks, we don't think that, we think the other way, how do you base it? This is why, and maybe I spoke too glibly, this came down to 5-4 cases, right? A Bergfeld's a 5-4 decision. And if you had one other justice the other way, it would come the other way. And I don't think that reflects what is an innate truth. I don't think it reflects what is aspects of human dignity that maybe one person is a better philosophy than the other. We have different philosophy. Even in this class, my goodness, right? We have a wide range of views from across the spectrum, in which I love. I love that we have different perspectives. It makes me very energized. But how can a court rule when you have these sorts of divisive issues on which there is no clarity? And in which the democratic process was trending in one direction for sure. Look at this graph, right? But hadn't quite gotten there yet. And what would have happened if we lived in a world where 50% of the states had gay marriage and the other 50% didn't? At that point, it's a train that was reaching its destination. There was no stopping that train. Okay, children. All right, the zoo for the chids, right? I was thinking children, I said kids, and it just went off. All right, now some hands. Anyone want to raise their hand? Yeah, Dana. Oh, thank you. Yeah, the question was, what do you do when you have different motives, right? So again, let's just make up numbers, right? Let's just say that it's 95% of the motivation for DOMA was moral disapproval, and I think I'm making it up, but that's probably true. And let's say there was one member of Congress who really cared about choice of law, and one member of Congress really cared about conflicts of law. Right? Just one member of Congress, right? Just one guy out of 100. How do you assess that? So usually with strict scrutiny, we say that you have to have something that's narrowly tailored, right? In other words, you're using race in the least way possible, right? That you can't get there without using race in this minimal fashion, right? That's what strict scrutiny would say, right? And if you can get to your goal without using race, think of the quotas in Bakke, use it in a different way. Use the holistic approach, right? The multiple factors. But when you're dealing with rational basis review, it's a little different. You simply say, is this government program rationally related to a legitimate governmental interest? Doesn't have to be a perfect fit. It could be a general fit, right? Right? It's generally is using a single definition of marriage a rational way to have a uniform choice of law policy? Absolutely. And if we apply rational basis review, then that's the end of the story, right? If a state wants to have statewide policy on discrimination laws so that their businesses don't have to deal with competing regimes, is that rational? Absolutely. But the sort of rational basis review that the court applies in Romer, in Lawrence, and in Windsor is not that kind of rational basis. It's certainly not the Leoptical rational basis where they just make crap up. It looks a heck of a lot like strict scrutiny. Which goes to the point of why is the court not willing to just say we're applying a suspect classification? Because again, Justice Kennedy doesn't like scrutiny. I don't have any other answer for you. He just doesn't talk about it ever. Never mentions it. Doesn't come up. It just doesn't faze him. He believes everything is rational basis review, but he applies in inconsistent fashions. Does that answer your question, Dana? Okay, other questions? Yeah. Yeah.
So is it not enough that he says in,
It's a very, he says, yeah.
Where he says that, marriage is a fundamental right. Isn't that enough to
Well, marriage is a fundamental right. Marriage. But why is same-sex marriage?
Well, then it goes back to Mia's point, I think, because if marriage is a fundamental right, then under the equal protection of the law, we all people should be treated the same under the fundamental.
Well, a gay man can marry a woman. Why is not being treated the same?
Because that's an oxymoron. A gay man would not marry a woman.
Of course not. So you're asking for something new, aren't
That's
you?
not nothing new. Well, that's not. Well, okay. All right. So go back to the Loving case then. You're asking something new.
Actually, the new thing was the interracial marriage ban. In fact, interracial marriage bans came about as part of slavery in Jim Crow. Right, Virginia's law was enacted in the 1920s.
Got that? Okay, but look, let's stay with me. So,
Yeah.
right? Okay, so if marriage is a fundamental right, right? And so it doesn't matter who under that.
Well, how is
umbrella
marriage? But how is marriage understood in Loving? What was the purpose of marriage understood in Loving?
Marriage, I mean, if I remember correctly, was it a fundamental right then?
Oh, they said it was fundamental, but what was the right they're protecting?
Well, okay, so it's I guess the family, the procreation, the whole
procreation.
the idea of what marriage means. Okay, but let's fast forward though. I mean, so we have to fast forward. I mean, I'm not being facetious. We really do have to fast forward to 2015, where he specifically says, I'm trying to find it in there, but I can't find my quote. But he specifically says that Kennedy says marriage is a fundamental right.
He says that, that's right.
Mm-hmm.
He says that.
And so, case closed, right? I mean, case closed.
But if no country in the world understood gay marriage until 2004 or whatever, 5.
But you could bring that back to interracial marriage.
But
And
interracial marriage was a new
anomaly
thing.
At the time, right? At some point, everything is new. I mean, it's.
And we ratified an amendment to eradicate slavery and the badges and instances thereof.
And we ratified an amendment to also treat everybody equal. And
Was
have
the
equal protection
14th
of the law.
Amendment ratified?
All U.S. citizens have to be treated the same in each state, and equal protection of all human beings, all people.
Polygamy? How about that?
Okay.
I'm asking. In fact,
We don't have a meeting before.
polygamy's old. Polygamy's
This is exactly what we were talking about before we came to class.
polygamy was around the time of the Bible. Polygamy's old school. That's been around forever.
It's okay if women can do it too.
Kyle, rescue us, please.
Yeah, I was gonna. So, if you say Loving v. Virginia is to protect the fundamental right to procreational marriage, there are other constitutional cases, Supreme Court cases that have said that non-procreational people that aren't capable of procreation have a fundamental right to marry. So as long as there's that and the no-fault divorce, I think gay marriage becomes a fait accompli.
I think that might be right. I think if you take rational basis to mean that it no longer is with procreation, then once you decouple procreation from marriage, then the rational basis vanishes.
Boom.
Right, but let me just make this point clear. Who did that decoupling? The court, right? This is the point I'm trying to say. Marriage has changed significantly over the last 1,000 years, right? With no-fault divorce, we don't have the dowry anymore, right? Now the woman can say no if she wants to, right? There are a lot of, no coverture, for example, right? With the property agreement for women. There have been significant changes in marriage over the last millennia. But those changes were driven largely by the political process. So the question here isn't whether Janice and Josh can say, yeah, there's no good reason to have excluding marriage anymore. Maybe we can, maybe we can't. But which branch of government's ideally to make that position?
Okay.
We're on the same page?
not the judge.
By the way, the court ducked, the lawyer arguing for Windsor and also for Bergefell were asked about polygamy. They had no good answer. They oh, we don't want to do this, but you know, they're the sister wives, right? You know, there's a thing.
Or sister husbands, let's be.
Brother husbands.
The brother spouses, the sibling spouses. How about that? All right, let's do some law. Let's actually do some cases. Let's actually do some law. We did good stuff. I think Brooke, are you next?
Yes.
Okay, Brooke, you want to help me out here and give me the facts in Romer, which we already discussed in Toto, but we'll get to it.
All right, so basically, the case that made it to the Supreme Court was challenging an amendment to the Constitution of the state of Colorado.
Okay. By the way, Brooke, let me stop you for a minute. What's the significance that this was voted on by people, the ballot initiative, and not the legislature? Do you put any significance to that?
Yes.
Okay, tell me what.
Well, because it was the will of the people that
Yeah.
made the decision for this amendment to pass.
Yeah. Okay. All right. Go on. Proceed.
And so, okay, so we're referring to, the court referred to the amendment, it was amendment to, and so it was voted upon and passed. And basically, what gave rise to the controversy was the protection that the ordinances afforded to persons discriminated against by the reason of sexual orientation. And so the amendment 2 came in that basically said that there would be no protections, but they would basically be on equal footing with everyone else.
Okay.
And so there was no need for the ordinance to pass.
Okay. Very good. Thank you. So here we have a situation, right, where was it 95, 96, right? Bowers is still good law. Bowers is still good law. You'd think this would be a case where they say that Bowers was wrong, but Justice Kennedy doesn't even mention it, right? Doesn't even cite it. And we're in a place where the state can literally throw you in jail for having gay sex, but they can't withdraw protections for you. How can that be? Now, the court makes its opinion based on equal protection. And Justice Kennedy starts developing this line of thought that laws based on a bare desire to harm, this Moreno case. Let me talk about Moreno for a minute. This is an obscure case that no one even cared about, but it comes up a lot. It was a case from 1970, 73 or 72, 74 maybe. And it involved hippies. Congress passed a law which made it very difficult for people living in hippie communes from getting food stamps. And the upshot of the law was that if you had unrelated people living together, they were not eligible for food stamps. And the Supreme Court said that was unconstitutional, that this law is based on a bare desire to harm hippies. Now, hippies are not a suspect classification. They're non-suspect. But this language is in there. And Justice Brennan said a bare desire to harm is not a rational basis. So Justice Kennedy looks at the history of Proposition 2, or Amendment number 2, and he says that this is, premised on a bare desire to harm. And I found some pictures. This is one of the commercials paid for Colorado for Family Values. And if he says it's S&M leather contingency. And the theory is that if you vote, if we allow protections for gays and lesbians, this is what we're going to wind up with, whatever that is. And there are various propaganda and commercials and the like for it. Okay? Is this law, in fact, based on disapproval? Yes. It is. Is this law based on desire to harm them? That is actually disputed. So, Moniqua, how does Justice Scalia, in dissent today, in Romer, characterize Amendment number 2?
He said that, I'm just going to go in order of my notes, so I'm going to give you more than what you asked for, but I'm going to give you what you asked for.
That's
so
fine.
He said that, it says in holding out that homosexuality can't be singled out for favorable treatment.
Mm-hmm.
The court contradicts the decision of Bowers, which was never brought up.
Right.
And he also says that homosexuality, according to this opinion, is being put in the same category as
race or religion. And then he goes down to say that this was only saying that the opinion is saying that homosexuals may not obtain preferential treatment without amending the state constitution. But he's saying that basically they couldn't be favored for being in that class.
Good, very good, very good. So we have a disagreement between the majority and the dissent, a very basic disagreement. The dissent says this law is denying benefits to gays and lesbians in Colorado, right? It's harming them. Scalia says, no, it's not harming them. It's putting them on equal footing, right? So let me see if I can summarize this. On the one hand, you're saying you can't discriminate versus you can't add extra benefits. You can add extra protections. And depending how you look on it, it's a very different case. And I don't care if you go with Scalia or Kennedy, it makes no difference to me. But I want you to understand both sides, right? If you're looking at this as Kennedy, it's saying that the people of Colorado voted to impose disabilities, stigmatizing the gay and lesbians of the state, right? That they're singling them out for this disparate treatment. And Scalia says, what are you talking about? That's not what's going on here. They're simply saying that they should be treated in the same fashion without any additional benefits. In fact, Scalia calls the people of Colorado tolerant, right? That they're trying to move incrementally. So this is a theme that pops up a lot. Incrementalism. What does that mean? That when there's a fast-changing social condition, that the government can take steps to deal with the situation slowly, incrementally. For example, DOMA. When DOMA was enacted, there was actually a state Supreme Court in Hawaii that ruled that the state constitution protects gay marriage. And that was overturned, or civil unions, I'm sorry. And there was a fear that if we allow this to happen, then all the states will have to recognize, under the full faith and credit clause, foreign marriages. So we're going to put this in as a stopgap measure, and we'll deal with it maybe later. And generally, with a rational basis test, the government can move slowly, right? But here, one second, Kennedy says that this is not an act of toleration, it's an act of harming. Yeah, Adrian, go ahead, please.
Do you suppose that the law was written to impose stigmatization, but that the people were misled in their voting?
What do you mean? I don't know if I understand your question.
Okay, so I feel as if maybe this law was written as a way to discriminate against homosexualities on the basis of a moral issue, but that when it was promoted to the voting body, that it may have been promoted in a way that we're trying to make this equal for all. And it's because
I see your point.
That a group of people, the majority, would openly. I just don't believe that.
Well,
I just feel like that was something.
I'll get a second, Mark, I promise. So let me answer Adrian's question. I think it's all the above, right? I think that there are some people who firmly believe that if we allow gays to go forward, we'll have these S&M people marching on the street and whoever else does stuff, right? I think other people said that, I don't really know what this gay stuff's about. It was the 90s, different time. Let's just move slowly. And maybe some other people said, well, I don't really know, but I don't like people being given special benefits that I don't like very much, right? I think it's a mixed bag. When you have thousands of people voting on a referendum and you don't know why they're voting, I think there's a mixed bag. And I don't know why, you don't ask someone, why do you vote the way you voted? My goodness, tomorrow everyone should go vote, but no one asks you why you're voting the way you go vote. Yeah, Mark, yeah.
I'm just going to, it goes back to with right now with voting and like Proposition B that's on the ballot, which is for firefighters in Houston to have a raise, and there's so much more information that goes into it, but there's making it seem like, vote for this so we can give our firefighters a raise, but there's a whole bunch of other stuff that's happening.
Yeah, are you, what a good analogy. Thank you, Markia. So is it like, are you trying to give an undue benefit to cops, or are you trying to make it equal for firefighters, right? Which one are you doing? Yeah, that was a good analogy. I like that. Anyway, go vote everyone tomorrow. It'll be long lines, I'm sure, but you should go vote. Or if I already voted. I already took care of it. I went last week. Yeah, Clay.
Can you go back up incrementalism real fast? When there's a fast-changing social issue.
That sometimes the government can move in steps. All right, maybe they say at some point we'll deal with gay rights on a statewide basis, We don't want each local county having different policy because it makes it harder for us to proceed. Right? We move in increments, incrementalism. Right. So again, and I'm going to wrap up Romer in a bit because we have to move along. But in Romer, the court basically held that this was a unique stigma, right? That never before had a law been passed to impose disqualifications on single class people. That is not humanly true. That's not remotely true, but Justice Kennedy's world, it's true. Again, he has his own sense of history that's often in a world of his own. But in Kennedy's world, there's never been a law passed to impose disabilities on one class people. Okay. As a result, it's a violation of the Equal Protection Clause. One argument that didn't gain traction here that may have is the Caroline Products footnote 4, that you actually have by ballot referendum, making it harder for certain class people to get redress, right? Because imagine that you were a resident of Boulder, Colorado, and you persuade your city council to give certain protections to gays and lesbians. And now the state trumped that. And the only way for you to impose protections for gays and lesbians in your community is to now re-amend the state constitution or run to Justice Kennedy. Either one's just as easy, right? But it makes it harder for the political process to affect certain changes. Does Justice Kennedy even mention any of this stuff? No, because none of it matters, right? This is why I say this is Kennedy's world. We're just living in it. He has his own vision of what he wants to do, and the other 4 don't really care because they have the votes. Or actually, in the case it was 6, I think O'Connor went along with it. I'm sorry, what was that?
I want to see the wording of it.
The wording of the amendment?
No, the wording, yeah, amendment 2. That's what I was looking for.
The Colorado one, yeah. Oh yeah, pull it up. If you want, raise your hand later when you get to it. I think it's in the opinion. I think it might be in the full opinion. Yeah, we may have edited it up. I'm sure it's in the full opinion. Because usually these ballot initiatives are pretty short. It's like a sentence or 2.
So he ignores footnote 4, or he just doesn't talk.
He doesn't talk about Bowers. He doesn't talk about scrutiny. Doesn't talk about footnote 4. Right? He's in a world unto himself. I used to say we're all in Anthony Kennedy's world, and we're just here, but now we're not anymore. So I can talk about it. We were in Anthony Kennedy's world, the most influential man in America for 3 decades. No longer. All right. It's not. It's actually whatever comes next probably worse, but it's always at least I can have a few breaths of freedom, right, from Kennedy's opinions, right? All right. Any other questions on Romer? All right. Let's do Lawrence. So in the years following Romer, there was a lot of uncertainty among lawyers about where exactly sexual orientation fell in the hierarchy of rights. It was an open question, right? Because Romer didn't really address Bowers, the still good law, and you didn't really have any firm movement. And indeed, in the years following Romer, a number of states amended their constitutions, including Texas, to prohibit same-sex marriage. And these were on ballots throughout the country in the early 2000s, in the 2003, 2004, where lots of states had these amendments. And the reason why was you had Canada and other nations in Europe trying to legalize same-sex unions. And there was a fear that our state would have to recognize those marriages. Then we come to Houston. Right? You're laughing. This is a case that arose in our backyard, quite literally. The facts of this case are absolutely nothing, even remotely close to what Justice Kennedy said. Not even in the same ballpark. So the standard account is that 4 sheriff deputies from Harris County came to the home of Lawrence and Garner. There's Lawrence and there's Garner. And they found them violating Texas's sodomy law. But the facts are actually quite different. Mr. Lawrence, who I think did pass away a couple years ago, was interviewed, and I'm going to read you this quote. He said, "My God, we didn't have sex." So this is the actual facts, which did not make it to Justice Kennedy's opinion. When Randy and I were recording the video, we debated including this. We decided not to because it was just too much to say, but I'll do it here. So there were 4 officers, right? So first off, why were they there? Did I mention this last week, this story? So Garner's boyfriend got jealous that he was with Lawrence. So Garner's boyfriend calls the cops. No. Or was it? Oh, which one was it? I thought it was Garner's boyfriend.
Maybe so. I didn't realize that was another boyfriend.
You know what? I don't want to.
It didn't say.
I thought it was Garner's boyfriend, but maybe it was Lawrence's boyfriend. I'm screwing this up. It was one of their boyfriends, right? One of their boyfriends called the cops, and they basically said, "There's a black guy with a gun in this house," which is why they sent 4 deputies in there. Yeah, 2 seconds they were there, right? It's unclear if they had a search warrant, and Justice Kennedy alludes to this and just says doesn't matter. I'm almost certain this was not a lawful search. And as you know, when you have an unlawful search, you exclude the poisonous fruits, right? You exclude the evidence from the search. So this would have been an easy Fourth Amendment case, but the court didn't care about that. The cops show up. Again, they sent 4 guys there. There were 4 guys. 1 recalls seeing oral sex. 1 recalled seeing anal sex. And 2 didn't see any sex. Now, you can't confuse those acts, my friends. They're not, they're not confusable. You can't confuse those acts. As best as I can piece together, they were probably not clothed, but they were on the bed, whatever, and I'm going to leave it there. Okay, but they were not engaging in any sort of sexual acts, according to Lawrence himself. They were then arrested. They were booked. And at the time, we had a prosecutor, the DA. His name was Chuck Rosenthal. He is an alum of our law school. He was terrible. He was a very bad lawyer. He decided, he decided that he wanted to prosecute this case to build his political career. Everyone urged him, do not fight this case. You're going to lose. Everyone told him. Our Attorney General at the time was Greg Abbott. He was like, do not take this case upstairs. Our Solicitor General was Ted Cruz. Do not take this case to the Supreme Court, or let's argue it. No. The fear was that they'd lose. The fear was that they'd lose, right? But under the Texas separation of powers, the DA keeps his own cases, which is an absolute travesty. We have a good SG. We do not need the DA arguing our cases. But he argued this himself. He was terrible in the court. He was utterly unprepared. At one point, Justice Scalia said, don't fall into that trap, because someone was asking him questions. When Scalia is saying, don't fall into a trap, you're in trouble. At another point, Justice Breyer said, I'd like a straight answer. And then Justice Rehnquist said, maybe we should go through counsel, because all the justices were talking to each other. Justice Ginsburg asked a question, does Texas bar gays from adopting children? He says, I don't know. He was unprepared. He couldn't answer any question. He was terrible. But the point is, he didn't have to prosecute this case. And had he not prosecuted this case, we wouldn't have had it. It wouldn't have gone to the Supreme Court. And we wouldn't have had this decision. He didn't have to appeal. He could have just let the case go. He could have just let the case go, dismiss the charges. But he wanted to prosecute it. So again, the Supreme Court cases we have are often a product of political circumstances that don't make sense in hindsight. He thought he was going to make his career on this case. Just Google Chuck Rosenthal. You can see. I think he resigned. I can't remember. It didn't end well. But this was a disaster. All right. Any other questions on that? The reason why we didn't put this in the video, we debated it. We said it would be better not to.
Yeah. So obviously the witness testimony was very conflicted. How did they get a conviction out of that?
There was no conviction. They simply pleaded no contest. And the penalty, this is actually, there was not really even a trial. They pleaded no contest, which means that they don't accept guilt, but they don't have to go forward, and they can challenge on appeal. And apparently the lawyers actually asked for a fine. That way they have something to appeal on. Okay. So there was some sentence. So yeah, he could have just dropped the charges. And he didn't, which was a mistake. Yeah, Chris?
This is kind of a segue away. But
please.
What happens
when you, okay, you're just like putting all these people's business out there, right? Because they have to go through these whole legal proceedings. Like, what if we
Yeah.
didn't even know if they were gay? And now it's just like,
No, that's a good point.
like, do they get like civil damages for like, what happens when you just like put your whole life out there? What, they didn't want this, you know?
Well, so Kristen raises a very good point, right? Because you basically tell the entire world that you're a gay man, and I don't want to display this. This was an interracial gay relationship. This was even yes, it was even bigger, a bigger deal. So two things. First, the gay community really wanted a case to bring up, and this was their case, and they were able to persuade Lawrence and Garner that this was a worthwhile endeavor. For what I've read, that they didn't have fairly deep roots, that they were both openly gay and they didn't really care. But you can imagine a different situation where they weren't openly gay and they didn't want to deal with this at all.
Like we were talking about in Roe, like
Bingo.
She didn't want to be a poster child, like, and that's what she became. So do they get anything? I mean, I get that you're like making historical law, but your life is just kind of ruined. in my opinion.
Yeah, and I mean, they didn't bargain for this. They were just two guys doing whatever.
Exactly.
And they sort of stumbled into them. Yeah, I mean, but in contrast, I'll just jump ahead to Edie Windsor. She was born for the role. Edie Windsor, she's living it up. Like she wants this role. But Garner and Lawrence, they didn't. And I think Kristen makes a fair point. They could have easily just told the lawyers, we want this to go away. We don't want to appeal this. Let me just pay it was like a $100 penalty. Let me pay my fine and go on with my life and no one will ever know my name. But they didn't. It was a very different place, 2003, not what it's today, different world. Yeah, Kanisha.
But doesn't that make the point? So what I was going to say earlier was when we were talking about the age discrimination cases, one thing you said was that eventually you kind of graduate out because you get older. Your age changes. And so there's part of the reason why there's not strict scrutiny for ages. So I was thinking the same thing as when your sexual orientation is generally not on display unless you put it out there in many cases. But race would be different, whatever race it is. When we were talking about the Yikwo or the Plessy, your race is something that you can't change it and it's constantly on display. Yeah. Your sexual orientation is something that you very well may not be able to change, but it's not always on display. So those are two different things, regardless of the fact that you may be born with them. One of them, you can't hide.
And then let me just respond to Kanisha in a minute, and I'll come back to you guys in a second. One of the reasons why I think you have this graph where if you look at the speed at which acceptance of gay marriage was embraced, and you compare it to the speed at which interracial marriage was embraced, we're very different trajectories, right? It took decades, not 10 years, decades for a majority of America to accept to accept interracial marriage. Decades. I'm talking like 50 or 60 years. I'm talking, and this one, 5 or 6 years, 6 years, all right, whatever. And I think part of it is indeed that I think race does have a unique place, and I do think the 13th, the 14th, 15th Amendments speak to that exact dynamic. I saw another hand. Was it Kristen or someone here? Mia?
Yeah, no, I was just going to ask, Kennedy, to your point, I mean, part of the reason that people aren't going to walk around, and when you're a target of hate crimes and stuff like that, you're not going to walk around and identify, especially when there's a stigma. But Kennedy said that ultimately it's, when you talk about the democratic process, he said it was irrelevant because it's a right. So when you come across,
But how do you know it's a right though? That keeps circling back to the same point.
Well, that's what Kristen was talking about as far as like their privacy and the invasion of all of that when he came back to like liberty protects from unwanted governmental intrusion into the dwelling of private places.
So that's a Fourth Amendment search. They can't barge in without permission. In other words, all these questions keep coming back to a single point. How do you know what a right is? How do you know what liberty is? What tells us what liberty is?
I mean, and just discreetly to the Lawrence case, I mean, that's a pretty clear one there, is it not? I mean, that one ties back pretty well with like the intimacy of the bedroom with Griswold and like what goes on within behind closed doors. You know, I mean, this isn't something that's actually.
Well, I think the case for a liberty in Lawrence is very different than liberty in Obergefell, right? Because one is saying you can't come to someone's bedroom and arrest them for having sex, and the second saying we have to give you a government license, a piece of paper. I think they're very different stories. And it's a criminal matter too. You're actually literally throwing someone in jail versus saying we have to give you a benefit, a marriage license. Jeremy?
Oh, I was going to make a comment regarding why I just a theory of why maybe same-sex marriage was accepted in a faster trajectory than interracial marriage, and that might just be the invent of social media and the
Twitter.
You see more LGBTQ people in TV and movies and productions than you did when Loving was decided. You sure as hell it was almost illegal.
Captain Kirk and Uhura, right?
Yeah. Well, besides that.
That was a big one.
Did you really go?
Comparatively,
It's true. That was a big deal.
It was huge for the day.
Or it could be also that.
Guys, just one at a time,
That
please.
the road was paved because of the civil rights struggle of the African Americans throughout the decades.
Okay.
So it was paved for additional subsequent civil rights issues.
All right, good. So let's go back. I want to cover Lawrence. We're running precariously low on time. We have 45 minutes left. I see nodding heads. So the opinion in Lawrence, right? Again, Justice Kennedy is somewhat fuzzy on the reasoning. So I actually want to start with O'Connor, right? I think O'Connor gives the most straightforward opinion in the entire case. Justice O'Connor writes concurring opinion. She says, look, I joined Bowers, but I don't want to overrule it. So she draws a distinction. Bowers, right, said that you can't have any sodomy. Man, women didn't matter. Texas's statute was different. Texas's statute said that heterosexuals can engage in these acts, but homosexuals cannot. So Justice O'Connor said that that is irrational. It's a form of gender discrimination, right? Now, why is that not an intermediate scrutiny case? Why is it rational basis? What was that? Yeah, you're mouthing something.
That was what I was wondering the whole time on that question, on our first, when you started your question.
Ooh.
I was wondering why you put rational, like why is it not quasi, or like why was it intermediate? But I figured.
Oh, I'm going to ask you that question. Why? O'Connor says equal protection. Why isn't she given intermediate scrutiny? I mean, that might make sense. It's a sex classification. Because what? Yeah.
The majority chose not to.
Well, O'Connor could have. Well, let me ask you this question, you are another way, right? O'Connor stresses in her opinion that this doesn't affect lawful marriages, right? If we start applying intermediate scrutiny to laws that treat gays and lesbians differently, can marriage law stand? The answer is no. This goes back to my question with Janice a couple minutes ago, right? If you try and say, do the marriage laws make sense? Is there an important, substantial reason for it? The answer is probably not. Right? Maybe not. Maybe yes. I don't know. But I think the court's struggling, at least in Lawrence, not to go there because they don't want to go there. So O'Connor says, well, we'll just use rational basis review. They're all doing these twists and turns because they recognize the second you take away moral disapproval of homosexuality as a rational basis, the marriage laws can't stand. Right? Administrative efficiency, incrementalism, these various other interests, those are all well and good for rational basis world. But if you want to apply something more meaningful, it doesn't stand. And they're struggling mightily to keep ourselves out of that realm. Right? Now let's go back to Kennedy. Right? Justice Kennedy's opinion is very big on rhetoric and very little on law. He doesn't really give you the meat of his opinion. And Scalia is livid. He's always angry here, but he's really angry here. Who am I going up to? Cassandra, you next? No, I didn't want equal last. Okay, then to Tricia. Oh, did I skip you? Oh my goodness. You're so honest, Maniqua, thank you. All right, so Cassandra, I already did yours. So yeah, Cassandra, go ahead. Right? So walk me through the Kennedy opinion, please. And in Lawrence, that is. He wrote all these opinions. But give me the Lawrence one.
He said that liberty was guaranteed said that pretty much that what happens like in your private, like at the home that's private and should stay there. That that laws prohibiting homosexual conduct do not prosecute individual for engaging in such conduct. Legal that legal and social like society's already accepting homosexual.
Okay, so Daniel, let me go down to you now. At the time that Lawrence was decided, what was the general trend in state laws concerning sodomy? What was how are the states trending? They were repealing them. Okay. At the time the 14th Amendment was ratified, what was the general trend towards sodomy laws? So where does Justice Kennedy draw his light from? Does he draw it from the time of the framing of the 14th Amendment? Or does he draw it from the last couple decades? Why? Why does he feel that that's the correct place to draw the meaning of liberty from, and not the 14th Amendment's time it was ratified?
He has this concept of a living constitution.
He does, yeah.
Where what was liberty back then is not liberty now, and it's open to change in interpretation.
Very good. So, Tricia, let me ask you this question now. Assuming that we say the meaning of liberty evolves, how is a judge to know what that is?
So Kennedy used, like you said, the last few decades.
Good.
And what he thought society was thinking based on, like you said, the trends.
How are judges to know what that is, though?
Well, if you ask Scalia, you don't, because they're all Harvard and Yale, and they're not actually a good representative.
5 lawyers, huh? Yeah, 5 lawyers from the East, and Sacramento doesn't count. I love that line. I love that line. When I read that, I was like, oh, that was good. The vast in-between, right? Gorsuch was our first true Westerner in a while on the court. He's from Colorado. So I think Tricia, Sacramento does not count. His father, Kennedy's father, was a liquor lobbyist, in a capital town. But to go to Tricia's point, if we do say that this meaning of liberty can evolve over time, we've had this debate before in the context of Brown and other cases. But at least with Brown, we have this phrase equal protection, and that requires some sort of protecting equally. But the word liberty is much more broad. And if we know that there's a long-standing tradition of, say, criminalizing certain acts, and some states repealing it, then maybe the answer is just let other states repeal it, right? Or just don't enforce it, don't prosecute it. But Kennedy says that's not correct, that you can't wait for the political process because there's liberty. And how do you know there's liberty? Because you look to what other states have done. But Texas hasn't done it yet. Well, that doesn't matter. Texas is behind the curve, so we're going to push ahead. He says the laws and tradition of the past half century have most relevance here. They show an emerging awareness that liberty gives substantial protection to adult persons in deciding how to conduct their private lives in matters pertaining to sex. Therefore, there's a fundamental right to homosexuals to engage in sodomy. He doesn't say the word strict scrutiny, although it's basically what he's doing. Okay. Then he says, I'm going to read this passage. The state cannot demean their existence to control their destiny by making their private sexual conduct a crime. It is the promise of the Constitution that there is a realm of personal liberty which the government may not enter. I keep reading. He says, had those who drew and ratified the Due Process Clause know the components of liberty in its manifold possibilities, they might have been more specific. They did not presume to have this insight. They knew that times can blind us to certain truths, and later generations can see that laws, once thought necessary and proper, in fact serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles and their own search for greater freedom. Okay. Anyone want to respond to that? You want to comment? Yeah, Tricia?
I think in a way that is reasonable.
Okay.
I think if you look at where we're at right now and you look at things that we've had in the past, you can say, at what point does someone, I mean, who really thought slavery was okay? But it's because of where we're at now. It's easy to look back in hindsight and say, well, this all makes sense. Why was this a big deal? Why was this controversial? And I think one day these questions will be the same. 100 years from now, there'll be a class sitting in law school saying,
I'll still be teaching.
Controversial.
I'll be 134. I'll still be there.
So in a way, I think Kennedy has a point, but I also believe in the different branches and the checks and balances. So it's gotta be a fine line.
Why couldn't the democratic process then achieve this? If basically only 3 or 4 states had sodomy laws, I think I forgot the number, but let's say 5 states had it, and that had been enforced, why can't the people just repeal or simply not enforce their sodomy statutes?
I think it goes back to what Kennedy says. If you see as a whole that something's wrong, yeah, there still might be some of those holdouts, those few states, but you have to then provide the liberty to everyone.
The court. So is the court, think of it like a train, right? Is the court like the caboose riding the back, sort of like swaying back and forth? Or is the court the locomotive, right, pulling the train forward? Or is it, the snack car somewhere in the middle? You guys never rode Amtrak, did you? You know what the snack car is. There's usually a car in the middle with the snacks, and they're overpriced and they're disgusting. There's little microwave hamburgers are gross. Darren, wow, is it Darren? Danny and Yaren, I merged you. Very good.
I think what he's also alluding to without saying, because he doesn't like the idea of scrutiny, is going back to correlating products with no board. Because if you look at the states that still had it on the board, the majority, of course, wouldn't vote to repeal because they were in more of a conservative state. So the LGBT community didn't have the political power and the ability to go through and use the democratic process.
So, okay, very good. Yaren, you want to add something?
It was kind of off of what Trish said about how, it's back to that whole thing of when we bring to court, we think it's a good idea that they write something down or not. However, back to your reference about whether I think they're pulling the train rather than being pulled. And if you go back to what the Supreme Court was supposed to do, or what we can say they intended for it to do, it was never for them to pull, to basically pull to the way that we go. And I actually like the reasoning of some of these dissents made sense to me in the way of who are the justices to decide where our country is going. Because I guess to me it's like, when I like it, it makes sense to me, and I'm like, yeah, do that, go ahead. What about when we have justices that don't have the same beliefs, or don't have what the most people would agree on would be right in power, and then they just do and start pulling instead of the way the checks and balances are supposed to be. That was my
Yeah, very, very good point.
And I think just to piggyback on that, it made me think about, it was either there's probably Sylvia talking about the politicizing of the Supreme Court and how fragile the laws can be if they're making decisions based on the politics in the court or even the nation, majority of the nation, as opposed to what the amendments protection should provide.
Very good. I saw another hand somewhere. Was it Mia?
I just had a question.
Yeah.
So when the 14th Amendment was ratified, wasn't one of the sections in it saying that men voted?
It has to do with male suffrage, yeah.
So, and coverture was in place at that time still. So at the time that the 14th Amendment was ratified, women weren't equal to men. And then, there was the 19th Amendment in 1920. But how is it that women have a quasi well, I guess gender has a quasi-protected class, even though at the time the ratification of the 14th Amendment, women weren't intended to have equal protection of the laws.
So Section 2 of the 14th Amendment does reference male suffrage. The Equal Protection Clause speaks of persons, not men.
But at the time that the laws, that it was ratified, in the law itself.
So do we base our understanding of the law is based on what the framers intended or what the words meant? Let me give you an example. Ripped from the headlines. Let's talk about birthright citizenship again for a minute, right? If we understand the phrase subject to the jurisdiction thereof to mean people who are subject to our laws, then people born here to parents who aren't citizens are citizens. If we ask what did the framers intend, it's a much more murkier question because you didn't have the idea of illegal aliens back then. It wasn't a thing, and they didn't intend to perhaps profess citizenship. When you have different schools of constitutional interpretation, they often yield very different approaches. Did the framers intend to have schools desegregated? Probably not. Did the phrase equal protection have a meaning that you can't have the law enforced equally? It did. So when you choose words and you have words with meaning, sometimes those meanings are broader than the intent of the people who drafted them.
We're talking about deeply rooted at the time that the historical traditions at the time that the amendment was ratified is the point of reference.
Well, look, Myra Bradwell, right? Myra Bradwell was a lawyer, or wanted to be a lawyer, and she thought the Constitution protected her right. The 14th Amendment says nothing about men, it says citizens, and she was a citizen, right? Again, if you limit yourself to what did the people intend who drafted it, it's a fairly narrow document. If you limit it to what the words mean, they have pretty big meaning. I mean, look at the Declaration of Independence, right? All men are born equal, right? All men are created equal. The guy who drafted probably didn't really think that, but he wrote those words. And those words have meaning. And for decades, people read those words, that those words have meaning, which is why generally among originalists, and I don't want to start another massive debate, we originalists don't focus on the intent of the framers because that's not a good measure of constitutional interpretation because we don't know what individual people intended. We do focus on meaning of words. And the word subject to the jurisdiction thereof has a meaning.
Equal protection doesn't have tiers of scrutiny.
They do not. No, the entire notion of scrutiny is artificial. That's fake. Quasi-suspect, that's all fake, right? That's not a thing. Myra Bradwell didn't say, I'm a quasi-suspect class. She said, I want my privilege or immunity as the right to a license. That's what she wanted. She didn't ask for a quasi-whatever scrutiny. That wasn't her thing. And again, Myra Bradwell, she brought the case. She thought this was a plausible reading of the Constitution. She lost 9-1 or 8-1, but she brought the case. All right, I want to give a little bit on Scalia because time is flying by. Scalia writes, what Texas did here is well within the range of traditional democratic action, and its hand should not be stayed through the invention of a brand new constitutional right by a court that is impatient with democratic change. And he makes the point that it's not our place to intervene. Let the political process work itself out. Okay? Justice Scalia talks about bare moral disapproval. He writes that Bowers was basically overruled here, and the court adopted Justice Stevens' Bowers dissent. He said the fact that the governing majority of a state has traditionally viewed a particular practice as immoral is not sufficient reason for upholding a law. That's now the basis, right? Once you get past Lawrence, prohibiting something based on morality is no longer permissible. Okay? We have lots of laws that are based on morality. And he lists a couple, and it's a very infamous list. He lists fornication, bigamy, adultery, incest, bestiality, and obscenity. But I would add to that list perhaps animal cruelty. We prohibit animal cruelty because we think it's immoral. And he says now, if you actually take this seriously, the state can no longer pass laws based simply on morality. In the end, he says the court dismantles the structure of constitutional law that has permitted a distinction to be made between heterosexual and homosexual unions. Do not believe the court saying that this is so limited. And Scalia, as we'll see in a few minutes, proved to be quite prescient. All right, any questions on Lawrence? Anything on Lawrence? Yeah.
Go back just for a
Please,
second.
please, please.
You made a statement, you said, if the moral basis of the law, if you take the moral basis out of the decision, the marriage law will, I can't,
Oh goodness, I don't remember.
you know, does anybody remember what he said?
Did you say after Lawrence, any morality-based prohibition is not allowed?
Yeah, I said that. I think I said.
If the marriage, would,
Oh.
would end or something.
Yeah, once you say that you can't disapprove of homosexuality based on morals, there's no rational basis to exclude gays from marriage.
Oh, okay, that's what you said.
I think that's what I said.
Okay.
Okay, very good. Thank you. All right, any other questions on Lawrence? All right, we'll do Windsor fairly quickly. It's a fairly small excerpt in your case book. The Defense of Marriage Act, again, was enacted in '96, right around the same time as Romer was decided. And it was decided against the backdrop where at least some state Supreme Courts were starting to hold that their state constitutions protected a right to same-sex unions, civil unions as they called them back then. And the court also recognized that other nations had begun recognizing same-sex unions in Europe. So Congress enacted DOMA, and DOMA did a lot of things. But one thing DOMA did is it said that no state was required to recognize a gay marriage from another state. That's based on the necessary and the full faith and credit clause. I don't want to go too far into it, but I'm pretty sure as a matter of full faith and credit, that was unconstitutional. I don't think Congress can tell states what they can and can't recognize. I'll give you a few examples, right? So long before gay marriage was a thing, we had something called adultery. So let's say a person gets married in a country that allows adultery, and he moves to a state with his 2 wives. Does it say have to recognize both those marriages? The answer is no, right? States can say we will not recognize polygamous marriages. Let's say state A allows a marriage at 16 and state B allows a marriage at 18. And 2 16-year-olds move to the state. Do they have to recognize the marriage? The answer is no. As a matter of policy, they won't recognize underage marriage. Let's say one state allows first cousins to be married, another state doesn't. 2 cousins get married, they move to the state. Do they have to recognize the marriage? No, they do not. So there's a long tradition of states deciding as a matter of policy what marriages they will and will not recognize. I don't think Congress can get involved with that. I think it's beyond Congress's powers, but that's not important. So forget that for now. The relevant issue in DOMA for your purposes concerns federal law, where Congress said for purposes of federal law, we're adopting a single definition of marriage. One definition of marriage, a man and a woman. That's it. It doesn't matter where you got married, doesn't matter where you live, doesn't matter what country you got married, it makes no difference. Same definition. If you want to file a married tax return, you got to have a man and a woman. If you want to have Social Security benefits for spouses, man and a woman. If you want to get a disability or you want to get some sort of a pension benefit in the military, man and woman, right? If you're a civil servant and you want to have health care for your spouse, man and woman. Straight up, across the board. Okay. Why was this law enacted? We alluded to this earlier, right? The primary reason, I think, if you wanted to poll the members of Congress, was they thought that homosexuality was was immoral, was not moral. Another reason they said it was enacted was to make federal law easier to implement. If you have a single definition of marriage, you don't have to amend 5 million federal codes of all different regulations, right? It makes it easier to administer. That law, I think, was valid when Romer was decided, right? I think it was probably valid when you had Romer, right? It wasn't singling out any sort of disability. It was just making a single definition. At the time, you didn't have gay marriage in states. But after Lawrence, it becomes a hell of a lot harder to support. And there was one colloquy. Colloquy means an exchange. But there was one exchange during oral arguments between Paul Clement, who was the lawyer defending DOMA, and Justice Kagan. And I remember I was listening to the argument. I wasn't there live, but I listened to the audio and I read the transcript. I was like, wow, this is pretty important. I made a note of it, and I always come back to it. So Kagan asked that you have this report from 1996 where the House says that DOMA is designed to reflect and honor a collective moral judgment and express moral disapproval of homosexuality. Justice Kagan, who again she's a smart justice, her questions are wicked. If you get any question from Kagan, you're gonna get nailed. She's gonna ask what she wants to ask. Not all the justices are equally good questioners. She's real good. So she says to Paul Clement, "Is that what happened in 1996?" Moral disapproval. And Clement, who's a very good lawyer, one of the top in the game, says, "Of course," and the House report says that. "And if that's enough to invalidate the statute, then you should invalidate the statute." Can you imagine you're arguing in the Supreme Court and you say to the court, "You know what? If that's your test, then I lose." He's being truthful, right? He's being truthful. But then he says, "That has never been your approach, especially under rational basis, even rational basis plus." Again, I don't know if that's correct under Lawrence, right? If Lawrence is the correct standard and Lawrence's moral disapproval is not an adequate rational basis, then DOMA doesn't stand a chance, right? If you review DOMA with a meaningful, rigorous scrutiny, it's hard to justify. Now, I think actually could still be upheld because I'm a choice of law nerd. I think choice of law is very important. Conflict of law is a very important thing. I do think it's rational, but I'm a nerd. But once you get past moral disapproval, then DOMA is easy, right? And Justice Kennedy says that the Defense of Marriage Act is premised on a bare desire to harm, right? It stigmatizes, it imposes a disadvantage, a separate status on all who enter into same-sex marriages. He focuses a lot on the kids, the children. It makes people think that their parents' marriage is worth less than other marriages in the state. He says that people who voted for this were filled with animus, right? That the 300-odd members of Congress and the President of the United States who did this were basically bigots. Justice Roberts wrote a dissent. I don't think it's in your book, but Chief Justice Roberts wrote a dissent where he said that we should be very hesitant before we tar with the brush of bigotry the members of our coordinate branches of government, right? Before we basically call everyone in our government a bigot, from President Clinton on down. But the majority has no hesitation in doing so. At bottom, Kennedy says that there's no legitimate purpose to disparage and injure those people who the state sought to protect. Justice Scalia dissented. He said it's very tough to pin down a technical basis for the decision. There's no strict scrutiny. There's no fundamental right. It's sort of open-ended. But make no mistake, Scalia says, this is now the next step on the road to gay marriage. Yep, is right. Yeah, I mean, I've been here. I've been teaching here since 2012, and I was like, just for your saying, I was like, yep, guys, give it a couple of years, we'll be here. It was like, how do you describe it? As basically a train, right? And you knew where the train was going. There's only one stop, and it was chugga, 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 chugga. One step at a time, stopping local, stop, stopping. Okay, we're here. So when we get to 2015, it's like, okay, I knew that was coming. It was like the worst kept secret in law. But anyway, all right. I'm sorry?
He was just very harsh.
Scalia?
In this opinion, most of all. I mean, I'm not knowing that. Well, no. I think Scalia actually was toned down a bit in Obergefell. I think he actually came to peace. I think his Windsor dissent was much worse. You don't have Windsor in your book, I don't think, right? No. His Windsor dissent was much more angry than his Obergefell. I think by the time he gets to Obergefell, he actually toned down a bit, right? There's nothing about the homosexual agenda and the lobbying and other stuff. He toned down a bit. I think he came to grips with what was up. He saw the writing on the wall. He's like, okay, I lost. All right. Oh my God, yeah, for Scalia, that's toned down. You mistook a culture camp for a fit of spite. My God, the imperial judiciary. No, that was Casey. I think his Obergefell dissent with the 5 lawyers, that was basically toned down. He wasn't that. Yeah, he was not happy. You would not ride an elephant with? Oh my goodness, I would. Although for weight balancing, I think we might be. I have to go in the front maybe. What? Obergefell. So let me give the background.
So actually in 2015 or 16, after Obergefell decided, Jim Obergefell came to Houston. He came to Discovery Green, just a couple blocks over there, and I went to go see him. And, because I'm a nerd, I always have a constitution. I asked him to sign my pocket constitution. What else would I do, right? And I didn't really think about it at the time, but I opened up to the 14th Amendment. Long story short, when I was in law school, I asked Justice Scalia several times to sign my constitution. He refused twice. I got it the third time. Here was the trick. So I go to Scalia, will you sign my constitution? He says, no, go away. I asked him a second time, will you sign my constitution? He says, no, go away. So I asked Justice Thomas, will you sign my constitution? He says, yes. Thomas signed it. And I go, Scalia, will you sign my constitution? No, go away. Justice Thomas signed it. Give me. And he signed it. So if you go to my office, I have my wall in frames, the Scalia and Thomas signed constitution. You're welcome. But I had asked Scalia to sign my Second Amendment because it was after Heller. He said, of course not. But when I gave it to Obergefell, I actually opened up to the 14th Amendment. And he just signed it. He wrote, I blew it up here if you can't see it, but it says, Jim Obergefell, love one. And when he did, it's like, oh my God, you have Section 1 of the 14th Amendment, you have Section 2, 3, 4, and 5, and there's Section 6, the Kennedy Clause, right, the Dignity Clause. And it was just so poetic for me that he actually just wrote in love to the Constitution. It was I'm sure it wasn't deliberate, but I thought it was very well done that he did this. He was a very nice guy too. We chatted for a bit. I told him, professor, I'm teaching his case. He's all excited. Again, Kristen's not here, damn it. But to Kristen's point, these are regular folk, right? They're not people who woke up and said, I want to be a Supreme Court, whatever, right? They're regular people who were thrust into this huge thing. And I think he did pretty well for himself. I think he handled himself very well. Edie Windsor did much better because she loved it up. But the decision in Obergefell, which we've more or less talked to death already, was 5-4, right? The court recognizes a fundamental right to same-sex marriage. And they effectively say, I think Kyle alluded to this before, that there are cases. They say that marriage is no longer about procreation, and that responsible procreation is no longer a rational basis. But they tone back a bit, right? In Windsor, they make a big fuss saying that, if you believe in opposing gay marriage, you're a bigot and you're filled with animus. And here, Kennedy at least seems to suggest that, well, maybe reasonable minds can disagree. There might be religious differences. This is what I'm saying. I think it's more toned back. I don't think Windsor was a lot tougher than was Obergefell. I think by the time you get to Obergefell, it's like, okay, let's not go too hard in this one. The majority does not recognize sexual orientation as a suspect classification. They just don't mention it, which creates a lot of problems, right? What about follow-up issues involving adoption of gay couples and denial of different benefits, right? If the only right at issue is marriage, what about everything else? And there's a 1-2 line about the constellation of benefits, some such line, which I guess was alluding to the various benefits of marriage, but it doesn't really get you too far, right? The Obergefell opinion is quite long. I used to assign it the entire opinion to read, so you're welcome. I don't assign the full one anymore. Now you get the full travel ban, which I think is even shorter. All right, because I'm super duper short on time, are there any questions on the Kennedy majority in Obergefell, which I think we've talked through a lot? I'm sorry, maybe we ask.
Did you say quasi-suspect classification?
No, I said they said nothing about it one or the other.
Oh. But
They said there was a fundamental right which gives strict scrutiny for the due process clause. But Kennedy's analysis is somewhat vague about whether it's due process, whether it's equal protection. It sort of all jumbles together. Yeah, Danny?
So I think the one thing that everyone who wrote a case on this...
Everyone wrote, didn't they?
Yeah.
You've never seen 4 dissents. I don't think in any other case. I've never seen this before. The chief never writes dissents either. It's very rare. He was really pissed.
So what Kennedy dances around is it always comes back to moral disapproval.
Yep.
But they don't directly point out what is underlying of moral disapproval. I think that more likely than not it goes back to religious disapproval.
Mm-hmm.
How do you deal with that when we have the First Amendment and freedom of religion?
Oh, what a good question. So let me answer Danny's question. During the oral arguments, was it just Alito or Roberts? I think it was Alito. Maybe it was Roberts. It was either one. I can't remember which one. Asked the Solicitor General this question. He said, "Well, what if you have a private religious college that accepts federal funds, student loans, and they have married housing, married dormitories, which most colleges have, and they only let opposite sex couples use their married dormitories? Could the state then deny them funding?" And the Solicitor General said, "It's going to be an issue. I don't know." And I actually only learned this in the last month or so. Bill Eskridge, who's a professor at Yale, writing a huge book on, I think it's called, it's what a good title. It's on the gay rights movement. It's called From Outlaws to In-Laws. Isn't that an awesome title? Oh my God, it's like From Outlaws to In-Laws. Back in the gay marriage cases, such a good title. But Eskridge told me that apparently the SG was never asked that question. That all the people who mooted him and practiced were all basically like-minded. And no one thought to ask him the religious question. And he was unprepared for it. He basically said, yeah, it's going to be an issue.
I think what I was more getting at was the opposite side.
Oh, I blew your question. Yeah, sorry.
That makes sense too.
But ask your question again. If I blew it, I want to make sure I answer it.
Like the opposite side of that is if you have a moral disapproval of something and it's based off of a religion. Your religion, that's your belief, that's completely fine. But what makes it fair for you to place that religion on me? If that's where you're getting this moral disapproval. Like when you were referring back to like animal cruelty, I don't think that that's based off of a religious.
Well, why does it have to be based on religion, though? It doesn't have to be.
It doesn't have to be, but.
Traditionally, historically, most of our laws were based on religion.
Yes, but we have the First Amendment, which I think freedom of religion.
Which clause? We'll do First Amendment next class. But so you think it's an establishment clause violation to have laws based on morality?
Yeah, because it's freedom of religion and freedom from religion.
I don't want to do this now. Ask me this question on Wednesday.
Just one comment. If you research the historical framework of religion in general, it comes from cultural practices anyway.
Well, let's do religion on Wednesday. I'm going to do one thing at a time. But can you ask me the question again on Wednesday, please? Promise? I will answer it, but I have like 4 minutes left. Okay. Let's walk through the dissents. There are 4 dissents. And again, it's very rare to have 4 dissents in a case. And they don't all join each other, right? They join part here, part there. It's all over the place, right? Let's start with Roberts. By the way, my lecture notes for this class are 102 pages. Glad I got through all of them, right? You're welcome. Yeah, you're welcome. So let's start with Roberts. Roberts screams Lochner, right? Lochner, Marshall, right? Lochner, right? He's very much concerned that the court is making crap up, and that's about it. They're making stuff up. One note, he says that, I like this part, many people will rejoice in this decision, and I begrudge none their celebration. But for those who believe in a government of laws, not of men, this is disheartening. And he says 5 lawyers have closed the debate. Now again, this is Roberts, not Scalia. He's calling them 5 lawyers, not 5 judges, not 5 justices, 5 lawyers. So this was very, very bitter. He calls this under Federal 78 an act of will, not of judgment. So he was really pissed here. The next dissent was, I'm scrolling, my notes are way too long in this case, I have to shorten them. Scalia, right? And he says, today's decree says that my ruler and the ruler of 320 million Americans coast to coast is a majority of the 9 lawyers on the Supreme Court. Again, not 9 judges, 9 lawyers. And at one point, I got my favorite footnote. It's in your book now. He says, if I were ever coerced to put my name on the subpoena to give a 5th vote, I'd put a paper bag on my head. He described Kennedy's writing as the mystical aphorisms of a fortune cookie. In fact, when Scalia died, they made a little makeshift monument to him at the Supreme Court, and people brought paper bags, fortune cookies, and broccoli. Okay. Justice Thomas writes a separate dissent, and his point focuses on dignity. And he writes that dignity is innate. It's not something the government can give to you, nor is it something it can take away from you. So the entire notion that a law can deprive or give a person dignity is simply false. And then we have Justice Alito. And Alito actually defends the marriage law. Most people, the other ones, didn't really bother. And Alito repeats that this is a law designed to promote responsible procreation. Now, is that a persuasive justification? Is it accurate? Alito says it doesn't matter. It's not for us to decide. That if society wants to move slowly and incrementally and they decide to have these laws today and maybe not tomorrow, that's their choice, but we should not be ending the democratic debate. Indeed, no country in the world had gay marriage until 2000, and no state allowed it until 2003. The upshot of all this is that after Obergefell, again, I think I mentioned at the beginning of class, not much happened. There were some efforts to maybe resist the decision a bit, so to speak, but to this day, just about anywhere in the country, you can go get your marriage license. Now, there are some places where you probably can't get it and the judges won't give it to you, they'll just stay home that day. But just about anywhere in the country, you can probably get a gay marriage license. So you didn't see nearly the sort of massive resistance that you saw in a case like Brown that we saw to Obergefell. And for one reason or the other, I don't know why, but the history turned out quite differently there. All right, I went through those very quickly. Are there questions on the Obergefell dissents? Are there questions in the, yeah, Yaron? And I went through way too quickly, I'm sorry. If you have questions, you can ask.
Justice Thomas dissent.
Yeah.
He talks about our Constitution, the Declaration of Independence before it was predicated on a simple truth: one's liberty, not to mention one's dignity, was something to be shielded from, not provided by the state.
Yeah.
Does that move on? Because I think it was, I want to say it was Adrian who brought this up a couple weeks ago, talking about how there are rights not for them to take, rather as the state's providing them. Because to me, it felt like now it was the state tells you what your rights are, what your liberty is, rather than it's our liberty.
Well, it's not just state, it's the court, right? I think if you ask Justice Thomas, he would say that your rights are innate, you're endowed by your creator, right? The government can add certain rights to those. For example, they can pass a privileges or immunities clause, right? They can add rights to them. But it's not for the courts to simply invent new rights. That the courts are bound by the rights that perhaps you're born with and those that you have by statute. Justice Thomas is a firm believer in natural rights. He believes in that very strongly. But he would say that natural right means the government leaves you alone. It's not that they give you a marriage license, right? It's not that they're giving you some sort of positive entitlement. Right? Everyone know the difference between positive and negative liberty? I don't know if I've explained that before, right? Negative liberty, right? Liberty is generally viewed as a negative right. That is, the government doesn't do something to you, that they don't throw you in jail, they don't lock you up, right? That's a negative right. You know, the right to bear arms shall not be infringed. You can't violate free speech. You can't search someone, right? It's negative, putting limits on government power. Positive rights is something different, and Justice Thomas rejects this. A positive right is saying you have the right to a marriage license, you have the right to health care, you have the right to housing, you have the right to education. And traditionally, our Constitution says that rights are negative in nature, right? But Obergefell actually has a positive right to a government license, and Justice Thomas seems upset about that. Yep. All right, I got like 2 minutes left. Other questions? All right, so let me bring this all back together as best as I can. The state of constitutional law, I think, is somewhat in flux. The downside of Justice Kennedy's wishy-washy opinions is they can be ignored easily, right? There's no need to overturn it, right? You have to overturn Bowers to get to Lawrence, but I don't think you have to overturn Obergefell to limit gay rights, right? I don't think you have to overturn Holman's Health to limit abortion, right? Because his opinions are somewhat wishy-washy, I think they will be narrowed in the near future by the court. In our next class, we are going to speed through the First Amendment. And the reason why I saved the travel ban case for the end is it does involve the Establishment Clause, which Danny asked me about a couple minutes ago. So I will get your question, I promise. All right. Make sure you do the reading for Wednesday. It's on the bar. You need to First Amendment. I only have 1 day for it. Ugh. Okay. I'll see you guys in class on Wednesday. Thank you.